Thank you for coming. This is the third in the lecture series that is co-sponsored by the Law School and Maine Law Policy Group. And we try and bring in key stakeholders in the greater Portland area who have interesting insight and experience in different policy areas. So today we're going to hear from two very fascinating individuals with really interesting backgrounds talking about physician-assisted death and the right to die, which is a highly contested issue with a lot of really interesting arguments on both sides. So, I have Francesca right here. He is the Director of Clinical Ethics at Maine Medical Center. Additionally, he serves as the Assistant Professor of Medicine and Associate Course Director of Ethics and Professionalism at Tufts University School of Medicine. He previously worked as an assistant professor at both Bates College and the University of Nevada. He attended Dickinson College, where he obtained a Bachelor of Arts degree in Philosophy and Environmental Studies. He received a Master of Art in Philosophy at the University of South Florida, followed by a doctorate in philosophy at Georgetown University. At Georgetown, he focused on ethical theory and medical ethics. In 2012, he was awarded Outstanding Lecturer from Tufts University of Medicine. He regularly presents at national conferences and has numerous publications on medical ethics. His topics of interest include clinical ethics, example, end-of-life care, organ transplantation, and reproductive health. Medical ethics, such as methodology, just distribution of healthcare resources, managing relationships with industry, and research ethics, and general ethics theory. Valerie Lovelace is the founder and executive director of It's My Death, a 501c3 nonprofit based in Wisconsin, whose mission is providing services and education to people who wish to actively explore the meaning of life through embracing the certainty of death. Ms. Lovelace founded IMD in 2014 to fulfill a promise she made to her younger sister, who passed away in January of 2009 at the age of 49, to teach others how to deal with dying and death. IMD's goal is to help people connect with the reality of death and dying by living authentically and vulnerably. Ms. Lovelace is a retired Navy veteran, an intuitive healer and interfaith minister, an artist, and the mother of 3 adult children. She holds a Master of Science degree in Human Relations with an emphasis on counseling and a focus on the aid in dying debate, in which she completed her capstone project. Ms. Lovelace is chaplain of the Westport Volunteer Fire Department and volunteers with Funeral Consumers Alliance of Maine and the local hospice organization. Please help me in welcoming both of these wonderful speakers.
Thanks very much. She knows a lot more about, I have no idea where she learned all that about me. She must have been web surfing or something. Thanks for inviting me. Valerie and I talk, and both of our talking styles are to stand up. So I'm probably going to stand up and talk with you, if that's okay, and make sure that you all can hear me and the video can hear me. How's that? Good. Good. So, I guess I should first say I'm not representing Maine Medical Center or giving you Maine Medical Center's official position on this or anything like that. These are personal views. And I guess I should also say that my own personal views are somewhat on the fence on this. I can see advantages and disadvantages. But for the purpose of this discussion, I'm going to highlight, I think, 3 of the more important considerations that are against legalizing assisted dying. As I say, I think there are considerations on the other side as well, but I think Valerie will cover those, and so I'm going to focus on important considerations on the other side. I'm going to mention 3 of them. I'm going to do it briefly, so we have a lot of time for discussion afterwards. So I think I'm going to start with the one I think is maybe least compelling, and that's the slippery slope argument, it's often called. So slippery slope is it's an informal fallacy in logic, in informal logic. And the idea for slippery slope, for folks who don't know it, is that you're standing up here at the top of a slope, and the slope goes down here. And down here at the bottom is something that you don't want, that you don't like. And the idea is the slope is so slippery that once you take a couple of steps out on it, you can't help but slip all the way down to this really catastrophic bottom. So the catastrophic bottom people are worried about with physician-assisted suicide is something like the activities of the German medical establishment prior to World War II and going into World War II. So there are probably some students of history in here who know that many of the atrocities in concentration camps got their start as in the medical establishment with physicians euthanizing various subpopulations of people. Some of them in mental institutions, some of them with labels feeble-minded. And the rhetoric at that time was both, it's for their own good, who would want to live a life like that, as well as it's unhealthy for the German state. And so we had both arguments. And so people put that at the bottom of the slope. And the concern is that we will erode our feeling about the value or sanctity of life and end up somewhere down here. Now what's kind of interesting is thinking about where you walk on this slope. So most laws in this country say something like physician-assisted suicide should be available for people who are terminally ill. Some say, and in intractable suffering. And then there are various safeguards around how many physicians need to certify that somebody's terminally ill, whether the patient would need to go to a psychiatrist or a psychologist to make sure that the patient has capacity or competence to make the decision and make sure they're not under the guise of depression or something like that. Other places in the world, and indeed potentially in this country as well, start moving down this slope. So do you have to have capacity to get physician-assisted suicide? Okay. What if you ask for physician-assisted suicide as you're entering into Alzheimer's dementia, and then say, I would like it to be implemented in moderate or severe dementia when I no longer have capacity? What if a family says, we know mom or dad would not want to live with moderate dementia. We think you should be able to, we think physician-assisted suicide is appropriate for that. It starts then looking less like assisted suicide and more like active euthanasia. Okay? There are lots of people, and I can see good reasons for saying that for that population, but there are lots of people who say, okay, we're going further out on the slippery slope. Children is another instance where you might go and say, okay, this should be something we should be able to do to ameliorate the suffering of children who are dying from terminal illness, who can't consent to it. It should be available to them. Well, maybe yes, maybe no, but if you say yes, it feels like you're moving down the slope. And finally, some of you probably saw the article in the New Yorker about Belgium a couple of months back. But in Belgium, they've expanded the criteria away to include not only terminal illness, but psychological suffering. So in Belgium, people with depression can go to a physician, and there are some safeguards. 2 physicians have to agree. But a person with depression can say, I'm suffering intractably, I want physician-assisted suicide, please do it. And the article highlights, essentially somebody who doctor shopped until she found a couple of physicians who were willing to say yes, and then ended up. And it does appear that in Belgium, not only in sheer numbers, but in terms of the categories of people who are using assisted suicide is growing. So again, the concern is that we start here where it seems really reasonable for terminally ill patients who are suffering, maybe imminently dying, and we start adding folks, and pretty soon it becomes something, the New York article suggested that if you made a case to a physician and said, I'm unhappy, I've been unhappy for a long time, I don't want to live anymore, some people in that article argued, well, you should be able to do suicide. So it is essentially a legalization of suicide. Not that suicide's illegal, but you get the picture. So that's argument number 1, this concern that if we start stepping out of the slippery slope, we'll end up at the bottom. Argument number 2 goes to a distinction between killing and letting die. So in this country, withdrawing life-sustaining treatment and allowing a patient to die is legally permissible, it's ethically permissible, it's standard of care across the country. Probably the most important legal case in that series is the Cruzan versus Missouri decision in the Supreme Court. Back in 1990, I think it was decided. And our laws have tracked that. And essentially our laws have tried to draw this bright line between taking away unwanted medical care and allowing the underlying medical condition to take the life of the patient versus providing something that ends the life of the patient. In this audience, I hate to use the word proximate cause, but something like proximate cause, okay? And we've held to that. Now there's an underlying moral tradition that tracks that distinction. And it's a distinction between a deontological moral system and a consequentialist moral system. Very, very simply, deontologists identify types of actions that are always wrong. For example, is it wrong to lie? The deontologist would say, and you say, well, it depends. The deontologist would say, all I need to know about the action is that it is a lie. If I know it's a lie, I know it's wrong. Okay? So a deontologist would likely to argue that killing when it's not in self-defense is always, always wrong. And they have argued that suicide is always, always wrong. Okay? A consequentialist, in contrast, argues that there are no action types that are always wrong. It depends on the consequence of any particular action, whether it's right or wrong. So if you said to a consequentialist, is this lie wrong? Or you said, is lying wrong? They'd say, well, tell me about the lie you're thinking about. And you'd say, well, here's the lie I'm thinking about. It has all these good consequences. I'm not going to offend my friend, you know, blah, blah, blah. You know, very few negative consequences. And the consequentialist would say, usually, okay, that's an okay lie to do. So there are no action types that are automatically wrong. If you are embedded in some religious traditions, you kind of inherit a deontological stance about morality. And so there's this strong feeling that killing or suicide is something you just don't do. And it tracks along this feeling that there are action types that are automatically wrong, and that tracks back to some deep religious traditions. Think about the 10 Commandments. Thou shalt not steal. Okay, it's not thou shalt not steal unless the stealing has good consequences. It's thou shalt not steal. Okay, so you can see how that tracks. As I say, this distinction between killing and letting die is embedded in our laws, and when you start to erase that, there's a lot of medical care that's going to end up being changed if that distinction goes away. The third argument, and this is the one I find particularly compelling, I'll say I heard it most forcefully from a palliative care physician named Ira Boyack, and some of you might have read some of his books. But Dr. Boyack says his concern is that people will end up choosing assisted suicide because they are concerned about impoverishing their spouse, their surviving spouse. And he draws out a scenario where to continue to live with a chronic progressive illness would mean to continue to incur medical expenses that would have a bearing on the estate that was left over for the surviving spouse. And you can imagine this in a variety of different situations where you're trying, you know, there's an older person who's tried to save money all their life for their kids or for their grandkids, and they see it being slipped away into the medical system. Okay, and so it's not going to be there for their grandkids. You can see, as I say, a spouse worrying about impoverishing their loved one. And what Dr. Boyack says is, it's an easy policymaker decision, isn't it? Because assisted suicide doesn't take any money. We can kind of solve the problem of people suffering at the end of life, or medical care at the end of life, by just saying, let people do assisted suicide. Okay, so that's in a way an easy choice for politicians and policymakers. What would be really painful for politicians and policymakers is to fix the medical system so that people weren't worried about how they were going to pay for continued medical care. Now that would cost money. It would take a lot of hard work. It'd take better funding of palliative care, better funding of hospice, and so on and so forth. And Dr. Boyack argues that's really what we should be doing. So we're not forcing a very tough choice on individuals, okay, who may be choosing assisted suicide because, again, they want to save money for their spouse. They don't want to, Dr. Boyak's worried about forcing people into assisted suicide for financial reasons. Okay. Now that for me is a kind of compelling argument.
So, no, I have a question actually. I'm interrupting you, sorry.
Sure.
So there must be qualitative studies looking at how potential candidates for assisted suicide view this decision and what the cost to their family members weighs into their decision-making process.
Yes, maybe not exactly on point, but if you look at, right now I'm spacing who ratified assisted suicide in '97. Was it Oregon or Washington? Oregon, and then Washington came later. I think in Oregon, less than 1,000 people have opted for this throughout their entire, which suggests that there aren't loads of people being forced into this situation for financial reasons. And when you look at the demographics of the people who've chosen assisted suicide, you see they're usually upper middle class, well-educated folks, and it isn't being kind of foisted on the lower class for socioeconomic reasons. Having said that, that doesn't mean that in the future this wouldn't be a problem. So, for me, that one, so I personally, I discuss death and dying with 10 or 15 patients at Maine Meadow a week. And we help plan how they're going to get medical care, hospice, palliative care, treatment as their diseases progress. I know that financial considerations figure heavily into the considerations of the patients I talk to. So I am worried about that. Okay. Now, as I said, these were all arguments against. I really don't want to leave you with the impression that I think this is the worst thing in the world. I think, truthfully, as it is played out in Oregon and Washington, it's been okay. Thank you.
Are there any questions for Dr. Chesser right now? Because he does have to leave a little bit early before we have Val speak. All right, so you.
So first, I would like to say I don't disagree with anything Frank has said, almost. Mostly, though. These are very valid concerns. One of the things that I love about the law is there are ways to construct policy around those concerns to prevent abuse. And truthfully, not even prevent, because no law prevents crime. But every law provides a structure around what will happen if you disobey the law, are convicted and found guilty of having done that. And these laws are no different. I would like to draw a distinction first in the fact that euthanasia, which is an act where a physician is actively involved in giving a patient something to die, is not part of these laws in the United States. That is legal in 4 countries around the world, just most recently in Colombia, who passed their law this year after arguing about it since 1997, I guess, is when the court first ruled that a dying patient had the right to ask for and receive assistance. Here in the United States, what physician aid in dying means is that a terminally ill patient who is confirmed terminal by 2 physicians, normally that's a primary care and probably an oncologist or some sort of specialist involved in whatever disease process that individual is experiencing, confirms they are not only terminally ill, but as best as any physician can guess, within 6 months of dying, and are competent to make their own decisions. So that sort of eliminates the, if I'm on the cusp of dementia and I really want to have this and I apply for it, then later on I can have that used on my behalf by my medical power of attorney. That's not true. You have to be competent at the time of the request, throughout the process, and at the time you are going to self-administer your own medication. So no one can administer it, no one can help you with it, you have to take it on your own. And as Frank said, it's 859 people as of the 2014 report have used this medication. About 1,300 have requested it, so it's about 64% or so. They are all upper middle class, typically highly educated, enrolled in and receiving hospice and palliative services, so this works alongside of current medical practices. The law that was just passed in California recently that was signed by Jerry Brown, the California Medical Association, during that entire process of negotiations, actually withdrew their opposition to the law and took a neutral stand. Because they were willing to recognize that there are some very rare cases where an individual does die with extreme difficulty and current practices cannot help them. We just, despite our excellent palliative care, our outstanding hospice services, I'm a hospice volunteer, so I get to see a little bit of that, that there are some cases that are difficult enough that patients want to have this assistance and some physicians want to help them. The American Academy of Hospice and Palliative Medicine also said the same thing. They have a neutral stand. They don't support policy in favor, but they don't support policy against. Because they do recognize that physicians are at times asked to help a patient through difficult dying experiences, and some patients will want that. So, but having said all of that, I'd like to take a much more personal approach to this discussion, because I'm not certain when I'm dying, and notice I didn't say if, most people say if, I find that really funny. When I'm dying, I don't know that this is something that I would want to choose. So for me personally, I also have a neutral stand on it. What I believe is that any dying person should have what they need. And if that means for a competent dying person who can make their own healthcare decisions that they want this medication to help themselves when death becomes more imminent and they're drowning in body fluids, or, you know, I won't even talk about how ugly that can get. Who am I or anyone else to say no if we can make that a safeguarded process? What I like about the laws is it makes it legal and above board and trackable, and removes the risk against the physician, the risk to the family of running afoul of the law for assisting someone in suicide. No state prohibits suicide. If you stop and think about it, an individual who completes a suicide can't be prosecuted. There's no one to take to court. However, every state in our country prohibits someone assisting someone who wants to take their own life. And that is subject to an awful lot of interpretation. In the state of California, that's a felony. Here in Maine, it's a Class D crime. I guess the top sentence an individual could receive is up to 364 days in jail if you are accused of helping someone in their own life. If you have done that, and there is a concern that you might have done that with ill intentions, of course that can be escalated to up to and including a murder charge. So what the law's effort is in this particular case is to remove the physician, the patient, and the family from that mess, to say in this particular condition, terminally ill, competent to make your own decisions within 6 months of dying, you have passed all of the wickets, you've gone through the entire process of requesting, and then requesting again in 2 weeks, and then requesting in writing, and having the counseling sessions with the physician, that you can have this medication, and if at the end of your life you use it to finish things, you have not died by suicide in the eyes of medicine or the law, and your physician is not guilty of helping you die by suicide. So that's kind of the nutshell of it. I absolutely appreciate the ethical concerns, the moral concerns. I think these are conversations we should continue to have. I love that folks in medicine are now more willing to talk about how difficult it can be for some people, and talk about the fact that it has been kind of an under-table practice for a while if a physician is willing to help a patient. I've heard more than one story about that. So I guess I, at this point, would open it for questions from anyone, for either of us.
Yeah. One of the most interesting things about these sessions is we get to hear from you guys. So.
Right. Yes, sir.
If someone's dying and they think it's their civil right to, in fact, end their days as they see fit, leave aside all the financial questions, where is the best country in the world to go to?
Wow, that's a good question. I would say it depends on how you would like to end your life.
Well, not with a gun.
Well, you can do that in this country, sadly. Actually, I just learned that the Mainers age 65 and over have the highest suicide completion rate of any other age group. They don't have the highest attempt rate, but they have the highest completion rate. So as a resident of the United States, the only country you could go to receive assistance would be Switzerland. They are the only country that offers assistance to a non-resident. You have to send all of your medical history ahead of time. They have the same requirements as California, Vermont, Washington, Oregon, and Montana have in terms of being terminally ill within 6 months of dying, et cetera, et cetera. And you are after you go through all of their wickets, you would then travel there to end your life. As far as I know, that's the only country that will let a non-resident do that. There's actually a great documentary on that called The Suicide Tourist, if any of you are interested. Yes, sir.
One can establish residency, however, in most of the states you just enumerated, and it's not an extraordinarily long period of time.
Yes, you can. In fact, the young woman who is so much in the news, Brittany Menard, was a resident of California. She and her family moved to Oregon, established residency, and she ended her life a little bit over a year ago in Oregon. She had inoperable brain cancer. And so yes, you can. And it depends on the state's residency requirements. Generally, that's either a driver's license or an electric bill in your name or something like that. Of course, then you have to leave your family and your friends and your home and establish a relationship with a physician because it is required that you have a bona fide relationship with a physician. So it's not an easy thing to undertake. Vermont's probably the closest, yes.
What's the policy rationale behind the 6-month diagnosis up to the point of death?
Frank might actually be able to help me with that more. My understanding is that is the point at which you would be eligible for hospice services.
It tracks the federal hospice guidelines. It's an interesting question. You know, I think you're not in the medical field. You tend to use terminally ill as if it has a definite meaning. But inside the medical field, you know, line up 4 physicians in a row and ask them, you know, is this person terminally ill? You're going to get 4 different answers, all the way from no way they could live for, you know, to oh, they will be dead tomorrow. And and there are studies that show that's true. Physicians tend to overestimate how long people will live with an illness. But in terms of procedure, it gets really tricky because you're asking a physician to make a really definitive call on whether somebody's terminally ill. And you know, there are situations where you can certainly say that, but there are a lot more situations where there's not a sufficient evidence base to make a real clear call on whether somebody's terminally ill, which complicates things all over the place. When you're talking to a family of an incompetent patient and you're trying to help them make decisions, to say with certainty that somebody will die within a specified time period is pretty rare to have the medical certainty to be able to say that.
Yeah, I'm not certain any physician would ever say they are skilled at that. But that is kind of it's a ballpark that's used for eligibility for hospice. In hospice, we have this, it's kind of a joke that some people graduate from hospice, which is a great thing. Like, you go in there expecting that you're not going to live much longer, and you end up far exceeding anyone's expectations, which is great. The nice thing about the assisted dying medication is you don't have to take it. That's your option. Oregon actually tracks from the time a patient requests and receives the prescription until the time they take it. One patient lived over 1,000 days. I think that really illustrates that the laws don't promote hasty decisions. I can say, sitting by the bedsides of dying people, I've never met a dying person who really wanted to be dying. But I've met all of them recognize that they don't have an option at that point not to.
So I think there's some emerging research that was a couple years ago about how patients are really good at figuring out their own health status. Like, they know they're not long for this world, just to put it colloquially. And that helps them transition from intensive care to palliative care, for example. Do you know of anything like that in discussions for using patient perception to inform what their actual life expectancy is in terms of getting qualified for this sort of job?
Yeah, I don't. I'd love to see the study.
Yeah, it would be fascinating.
Yeah.
You know, there's a close intertwining between what's going on psychologically and psychiatrically and what's going on medically with people. The most difficult folks to counsel are folks who have a mental illness and a physical illness. And their decision-making about their physical illness is influenced by their mental illness. And to try to allow such folks to have the self-determination to make their own decisions, but also not have it be influenced by a really severe clinical depression or a psychosis or a fixed delusion is quite challenging. And just, you know, because we're in the midst of an epidemic of drug use in the state too, I'll also say that folks who are addicted to opiates, you know, that the psychological aspects of that, when there's also a severe physical illness, the intertwining of those two makes it very hard to decision make.
Is there another argument possibly against to be considered? And if so, what do you think of that argument? I mean, here's the argument that comes to my mind. That by saying it's okay in some circumstances, even narrow circumstances, it creates a sort of cultural idea that it is okay in some circumstances, and that some people, particularly adolescents maybe, who are prone to depression oftentimes and who are often, you know, or can be prone to kill themselves, might make it something that sort of seems acceptable and seems to make sense. You know, that concerns me, not knowing much about this at all. In the last couple of months, we've had two 16-year-olds at least in Cumberland County who've killed themselves.
I think the only thing that we can do is to make sure there is no correlation, and there does not appear to be, between the enactment of a law and a shift in suicide rates in younger ages. I have heard that discussion before, that there is that concern. You know, safeguards are the best that we can do in that case. One of the things I think is really important to emphasize is less than 0.5% of the deaths in Oregon are deaths by taking this medication. So if we equate that statistic to Maine, that means about 30 people a year whose dying circumstances are such that they would want this in addition to palliative and hospice services.
Yeah.
It's not a lot.
It's going to sound a little funny, but if I were to focus on quality improvement or some legislative effort to improve death and dying, it wouldn't be this one because it affects so few people. You know, and really as folks get a little bit older and their capacity becomes a question, this really isn't going to help, you know, our most vulnerable population of dying people, which is our geriatric population, because while some of them will have this as an option, there are very many who won't because their capacity will be a question mark.
I do want to just add to this, though, that the need to improve hospice and palliative services has been continually emphasized as a reason not to pass the legislation, and I think we really need to be careful in that case, because if you look at the data in Oregon, what we did see since 1997 is an absolute improvement in palliative and hospice services and access to those services by folks who don't want to use the law. The reason is the law states that a physician must inform a patient of their terminal condition and all services available to them. Many patients didn't know that they could have palliative or hospice care. They lived in areas where that may not have been available back in 1997, but it has worked dramatically in both Oregon and Washington to improve those services and access to those services. So it's kind of a double-edged sword.
I want to talk about, or ask about more about palliative care itself. This is a hypothetical, but I think it happens daily. Person is requested life-sustaining measures be suspended, but they're in a lot of pain. And their pain increases. And a physician helps to treat the pain as it increases or doesn't abate. Is there a certain point where a physician is pretty sure that a patient cannot sustain any more treatment, and what do they do? Or what should they do?
So,
what does the law say, by the way?
So Washington v. Glucksberg, Supreme Court case, covers this topic. So this is, in the field, we call it the double effect of pain medication, where pain medication has the effect of ameliorating suffering. It's an analgesic. At the same time, it may have the effect, the most common opiates, of suppressing the respiratory drive and hastening death is a kind of euphemism that's used. So are you allowed to treat pain to the extent where you risk or even are pretty sure that the patient will die because of the treatment for pain? And the answer is absolutely yes. That's a kind of a core principle that's taught in hospice and palliative care, and it's, you know, it's embedded in all the curriculum, and it's done absolutely every day, all the time. An interesting technique. Some people who've been on opiates for a long time tend to build up a pretty strong tolerance, so opiates aren't effective for their pain. You'll see this with a bone cancer, which is very, very difficult to treat the pain for. The kind of last ditch effort is to switch from an analgesic medication to a medication that induces a coma, like a phenobarbital. So it essentially, it puts you into a deep, deep sleep. And as a last resort, that's used. So you'll still continue the opiate analgesics, but you also use this kind of coma-inducing medication. And essentially, people will slip into a coma. They won't be aware of anything. Usually that happens when a patient is imminently dying. You're not feeding the patient will pass relatively quickly. But that's called palliative sedation to unconsciousness. And that's, you know, if I had to guess in Maine, I'd say that's used 20 or 30 times a year in Maine when there's intractable physical suffering that you can't do with opiates.
The AMA took the position you're describing almost 20 years ago of sanctioning the double effect and of making it clear across the spectrum of specialties and subspecialties that avoidance of pain is a legitimate treatment that physicians should pursue on behalf of the patient.
Absolutely.
The challenge is that not every physician knows that, and I wasn't aware until I had a hospice nurse explain to me, depending on the physician overseeing the care of the patient, if your primary care follows you into hospice care and they're not schooled in end-of-life prescribing, there are physicians who will actually say, well, I don't want to get my patient addicted, or they won't prescribe enough medication to manage that, and the nurses can't do anything without a doctor's order. And so oftentimes we find patients suffering because their physicians aren't aware that they can increase those doses at the end of life. That's the same medication that Frank spoke about that's used, that is prescribed if a patient wants to take their own dose at the end of their life. Some patients are intolerant to opiates. Some don't want to follow that process as they're dying, to be not mentally aware. They don't want to be in a drugged state. So again, it's, you know, it's kind of, it is very controversial, and it's a difficult determination to make.
This might be a little off topic, but could you just, given that it's happened in Europe, and particularly Belgium, you have children who are able to end life when they're terminally ill. Could you just speak to, first of all, whether you think that is something that we could possibly see in the United States, and second of all, just general, I'm sure you have more you both have more information on it than I do. So
the only thing I'm aware of in terms of the protocol is that it's not the child's request. It has to be an agreement between the parents and the physician on behalf of the child who is imminently dying, basically. I don't know much more beyond that. I think the only thing I can say in terms of whether that's a potential for the United States is whether we would agree to create a law that would permit that. And that kind of goes with how society's feeling about it and how lawmakers and physicians are feeling about it. There was an article, I don't recall, I think it was Connecticut, where parents just stopped treating a 5-year-old child who was terminally ill, dying of cancer. And there didn't seem to be a great outcry in that. I mean, I know 10 years ago, had that hit the news, people would have been, what? So the slippery slope argument is very real for people. My feeling is the kind of legislation we will end up with in the United States is what we allow ourselves to end up with. And that's why we have a legal process that either supports or opposes certain changes in our policy.
Frank actually needs to leave to go to a meeting, so can we just thank both the speakers right now? If anyone has any further questions for Val, we still have time in the room. Yell at you.
No, that's okay. Yes.
So considering this is a passive form that the doctors take to provide the dosage to the patient, and then at that point they kind of step out of the picture, is there a procedure or safeguard for what happens after the patient takes the medication? Like, so if, say, it doesn't work and then they don't die, what does the physician do at that point?
That in some cases, an antiemetic or anti-vomiting medication is given with it because that much of the medication can, in some people, produce a spontaneous urge to vomit. If you look at the data in Oregon, which is available on their health website, there have been a couple of instances where individuals have vomited the medication. Because they're imminently dying, they ultimately die anyway. I don't know the details of how those cases are handled, but that is a risk, and patients are counseled with, here's the risks of phenobarbital, pentobarbital, the medications that we'll be using. This is what could happen. This is what is likely to happen, and then a patient chooses or doesn't choose to take it. That is a potential. Yes.
As sort of a follow-up to my original question, what's the policy rationale behind the continuation of capacity? So if you've made the decision when you had the capacity to make it, there's been a change in your condition, but now you reach the 6-month thresholds, what's the policy rationale behind at this point for closing that possibility to you?
The policy rationale is that after a person loses capacity, they no longer know what's happening to them. So even if they are capable of holding the glass and drinking the medication, they don't know what they're doing. And so now you're getting into that area of euthanasia versus self-direction. And I get that question a lot from people who are concerned about dementia at late stage, that's increasing. It's a more real concern.
So I guess the logical next question would be what to do for those people, the people who do want this decision to have their own end-of-life care. They're not at the 6 months yet, and then they have a change in capacity. Are they just left to have to die the old-fashioned way?
Gosh, I hope not. So here's what I think every adult should have. Every adult should have a completed advanced care directive. How many of you have one? Ooh, some of you, that's great. So that's not just for old people with gray hair, that's for every adult. In the event that you become incapacitated for any reason to make your own healthcare decisions, that document would name someone else to make them for you. I highly encourage, if you're going to fill out an advance directive and name someone to be your advocate, that you tell them you've done that. Some people don't, and they're very surprised to find out now they have to make decisions and they've never had a conversation with you about what your values are. And you should also make sure that whoever your advocate is going to be, that they share your values and are able to see to it that your wishes would be carried out. So I just read a really great article about advanced care directives regarding a family who was desperately trying to care for an elder at home. That's what this individual wanted. She suffered from dementia. As that worsened, her family continued to try to care for her at home because her wish was, you're not going to put me in a home. You have to be willing at some point, I think, if you are not able to provide the care needed to go against the wishes of an individual, even if they have an advanced care directive. By the time this woman was taken to the hospital, she had bed sores from her shoulder blade down to her buttocks because she was a heavier woman and they couldn't rotate her and she preferred to sleep in a particular position. And so I think the best thing you can do for yourself or for anyone in your family is, number one, be willing to talk about dying, because talking about dying is not what kills you. Be willing to have the hard conversations and be willing to fill out advanced care directives. I've always made sure my son knew where mine was. He doesn't have a copy of it, but he should have. And I asked him last night, by the way, he's 28, rides a motorcycle. Do you have an advanced care directive? No. So we're going to be fixing that too. And also medical power of attorney. When you go into the hospital in a situation or to a care facility where you are either going to undergo a risky procedure or it's likely that you may not come out of there, they have a document now in Maine that's just being implemented called a POLST. It's a physician order for life-sustaining treatment that will translate your advanced care directive into physician orders. And so you would sit with a physician and go over those same questions of under what type of conditions would you want to have a feeding tube, would you or not want to have a feeding tube, or be on a ventilator or not be on a ventilator. And that will help your care providers in that facility be able to navigate around your wishes as well. Does that help?
Definitely, thank you.
Good. Have a will, too.
Is it, I recall, it's pretty easy to find the advanced healthcare directive form online, right?
Yes, if you just Google for Maine Advanced Care Directive, you will find that document. Yeah. You can also get a copy of the POLST, too, just so you can look at it. But that's not, at least nowadays, not something you fill out in advance.
And if you go to the doctor and you don't have one and they ask you, they'll give you a form.
That's right.
Every time you go to the doctor.
Yes, in addition to giving a paper copy to the person you've named to make your decisions, give one to your physician, get one in your medical record. And by the way, if there are individuals that you don't want making medical decisions for you, put them on there as well. I just recently learned you can do that. That might prevent squabbles over your body.
All right. Thank you so much.
Thank you very much.